project. Does it fall under either a categorical exemption, which is sections 15300 through 15332? And those are kind of smaller scale projects where it's generally perceived that they won't have environmental impacts, or a statutory exemption, which is one that's specifically listed by state law. And then there's another one that's called the general rule exemption, where there's no possibility that this project would have an impact on the environment, and so that's another carve out. As part of the CEQA process, let's say it's not subject to the exemption, then you go into the next stage, which is going through the initial study process. So you don't get to take your exit off. Instead, you're going towards either a mitigated deck, which is where you have impacts that can be less than significant, or if you do have significant and unavoidable impacts, then you're doing an EIR. Now, the categorical exemptions are the ones that you guys will see probably most often for most projects itself. This is really covering, a lot of smaller scale projects, more infill type developments and stuff that really isn't going to have tremendous impacts to the environment itself. That said, categorical exemptions are not necessarily absolute. There are, as part of the exemption, exceptions to those exemptions, and really looks at kind of the nature and location of the project. So really is, hey, if this project may be scale, but it's in a location, a spot that is going to have a tremendous impact, then it would not qualify for that particular exemption. And then kind of the next scale that you guys will see most often outside of the exemptions is the mitigated negative declaration. Really, it's either MND or ND, and it comes down to whether or not any sort of mitigation is required. And overall, it's based on the Appendix G of the CEQA guidelines, has a checklist of a number of different components that I'll go into as well. And then really it's based on facts on the record. It's a shorter public review period for it, and it's considered as a draft document until it's adopted by the Planning Commission. And then the EIR is kind of the bigger scale environmental review process. It does have a number of different types of EIR. So you have like a programmatic EIR, which is what the general plan has. It kind of covers a large activity. These are planning activities that may happen. As part of that, we're assessing what those impacts are. To a project level EIR, where this project may have potentially significant impacts that can't be avoided, but it's dedicated specifically to that action or that development project that's being proposed. Follows a very similar format to the MND with kind of the project description. However, there's a lot more detail that's required as part of that project description. You have the discussion of the environmental impacts and the analysis of what those impacts are measured against a baseline. What's unique about the EIR process is you also have your alternatives in the project. So you have to assess essentially what is the project. An alternative is a no project alternative if we don't do anything, and then other modifications to a project that are feasible that may lessen the environmental impacts, and using that as another decision point as part of what you guys may ultimately approve. And a discussion of the cumulative impacts, and then certainly you also include mitigation measures where feasible. This is really kind of the gold standard of environmental review. It has kind of the highest threshold of defensibility, but also can be pretty lengthy in review. It does have a number of different public review periods. So it has a 30-day notice of preparation. So before you even start EIR, you're saying, hey, we're gonna be preparing one. You're gonna have a scoping meeting, so you get public involvement at that start. Your public review period, rather than being like, let's say 20 days for MND, is now 45 days. So you have a longer period of time that people can comment. And then you also have to provide responses to those comments as well. And then the EIR is considered draft until it's certified rather than adopted, which is kind of a, don't know why they put it that way, but that's just a unique term as it becomes a certified EIR. And then as part of the review, all the documents itself will have these listing of studies or kind of topics that you have to address. So you have everything from agricultural resources and air quality to land use and planning, hydrology, tribal resources, wildfire, and then certain mandatory findings of significance. And then within these 28 different topics, you also have questions within it. So you may have one topic where you have 5 different specific questions you have to address related to that area. And then as part of that, you will also usually see technical reports that provide additional substantial evidence or help elaborate upon what those conclusions are in the environmental document. So you'll have 28 questions or 28 different topics, 3 questions within each different one, and then you'll have all these studies that may follow to help reinforce what those discussion points are. And as the analysis itself is kind of looking at a few different components. So you have your baseline. So this is kind of where are we starting from? What's the ground zero that the project's being evaluated against? The action you have kind of going from there that's going to create this impact. You have, as part of the review, a threshold of significance. So this is what we consider as, going to be a significant impact or less than significant. And then you'll also include mitigation measures that help minimize or rectify, compensate, or kind of reduce what those impacts are so that they fall below this threshold of significance. And really, each mitigation measure is going to have a who, what, why, kind of when approach. That way you have a measurable thing of this is what the developer is going to do, this is what the contract, construction supervisor will need to do during the grading phase, or the building inspector will need to verify this. And so you have this kind of enforceability of making sure that that mitigation is actually completed for the project. And then itself, within those different topics, so you have the biology topic, you'll have your secret topic and issue, you'll have relevant background information, your analysis of what the impacts are going to be, then the comparison to what that baseline threshold is, mitigation measures, and then you'll have a discussion about what the impact is after mitigation. And then as part of the analysis that you'll see within those different topics, we refer to them as either qualitative or quantitative. So like an example, the land use compliance section of the initial study or EIR is kind of more of a qualitative kind of discussion. It isn't necessarily like you have this like measurable outcome of number. It's more of the discussion point of how that impact is going to be. Whereas, let's say air quality, you run a model, you show kind of what the grading impacts are going to be, the construction, the long-term life of the project. You'll have, let's say, the South Coast Air Quality Management District thresholds, and so you'll go, okay, the number here for greenhouse gases is 3,000 metric tons per year, and the project is at 2,400, and so that 2,400 is below the 3,000, and so that's a qualitative or quantitative type of discussion. In the analysis, you'll either have computer modeling that helps run through what the project impacts are. You'll have site investigation, surveys, analysis of that, engineering studies as well, or other methods that are used to pull data and facts for the project. Then you may also have other outside agency coordination. So one of the examples that we have for cultural resources is all environmental projects that have a MND, ND, or EIR trigger tribal consultation. And so the tribes will review the cultural impacts and kind of go, this is what we see as a potential issue based on our knowledge of the area, the historical knowledge, or the prehistory of the site. And so they may also provide and weigh in on those impacts and make sure that those resources are being cared for. And then certainly, as I noted, you may have a number of different appendices on any given topic that really provide that in-depth analysis. Kind of the mantra is that the environmental document itself, kind of the one that you guys read, is supposed to be a public document. It's not supposed to be buried in a whole bunch of technical data, tables, all that stuff where you can't really understand it. Those go in the technical appendices, and the kind of the cliff notes of the impacts are what is supposed to be shown in the environmental document. However, they can certainly still be pretty lengthy because of, as I mentioned, the lawsuits that have kind of transformed that process. It is certainly a bit more of an effort to ensure that there's a complete administrative record. I will talk about one type of traffic analysis that is, or one analysis section that is interesting just because it's relatively new. It's a little bit harder for kind of the lay people to understand. So back in the day, not that long ago, California Environmental Quality Act really looked at level of service. So how does a roadway perform? What is the delay you have? That is no longer a CEQA threshold. It's really coming down to vehicles miles traveled pursuant to SB 743. So it's rather than looking on the capacity and the driver delay, VMT is looking at what is a land use occurring and what does that mean for people that have to use it? Do they have to drive farther to do it? Is a lot harder for them to get around? Is that something that creates where that driver dependency is a lot harder to manage? It is a complicated assessment, and really the mitigation is still not that well defined. That said, talking to traffic engineers, LOS itself is not really an environmental issue. How long, a traffic signal, you have to wait isn't really necessarily an environmental issue. It's more of a convenience factor of, when you're there. So the city still has general plan policies for level of service to address it, but it's not necessarily an impact. And then certainly traffic studies, when they kind of do it, run a very conservative kind of analysis. So you have all these different projects adding traffic and traffic and traffic on the analysis, but may not necessarily come to fruition. And so this is an example that is a street that's level service A. Obviously, it's a lot of land that's being maintained by that city, but no one's using it. And so that is certainly kind of one of the ramifications with level services. It does kind of create a difficult part for certain projects or places like in the city's uptown district where you have that more close-knit kind of fabric. Level service analysis specifically for that penalizes that type of environment, whereas you have this what's referred to as a strode in certain circles. That really isn't necessarily something that, while it's a level service A, wouldn't be what you would want to see in a place like uptown. Now I'm going to go through just some key terms that kind of play into the discussion. So one is a fair argument and then substantial evidence. These are kind of key elements of what the review process is. The fair argument is where someone can argue based on some degree of facts that a project may have a significant effect. And so it really is a low threshold that applies to NDs and MNDs that would trigger an EIR. The facts itself don't have to be absolute or unequivocal, but they do have to be founded in some sort of fact. So looking at a project saying, I think it's going to cause this because of this, this, and this, they don't necessarily have to provide a robust analysis to justify that, but it can't be just pure speculation. And so that does trigger, where an EIR may be required, whereas substantial evidence is really, you have to have a lot of data to back it up, scientific evidence, expert opinion, that can weigh against what it is. And so EIRs and exemptions themselves have actually a higher level of review because the fair argument isn't enough to overturn that environmental document, whereas an MND does. And then the kind of last two components is the lead agency. So you'll hear and see in your environmental documents that you guys are the lead agency. You guys are the ones that are carrying out the decision. And so that's something to remember. You guys are ultimately responsible for the CEQA determination if it's approved by Plan Commission, and then the same for City Council. So you guys we help prepare it, we help provide the analysis, and then it's ultimately you guys are weighing in on this is what we see based on the facts, what the impacts are going to be. And then the other component that's really important is the independent judgment. This is really that the analysis and conclusion meets what you guys are looking for as well. So as a lead agency, you're making your decision. If the developer says, hey, we're not gonna have a significant impact because of this, and you go, yeah, but we're looking at this fact, your opinion is what matters, not necessarily someone else's opinion. You guys are making that independent judgment. And so it's important to remember that as well. And then weighing in the facts and circumstances to arrive to your conclusion. And then certainly the CEQA process is meant to just disclose impacts. It's meant for both you guys as decision makers, but the public to understand what is happening with a project. And all of these actions have some sort of public notification as well. So if we have, let's say, notice of intent to adopt an MND that's going to the paper, we provide that circulation. Even the exemptions you'll see under the agenda is included, and it shows that when you guys are taking action on a particular project, here's what's also happening. And then certainly, why is it important? Well, most of the public comments you guys see tie into CEQA in some way. When someone complains about what is the traffic or I'm gonna have dust from construction, that is all tied to a CEQA-related impact. And so it's important to recognize that most of the comments we receive in some way thread towards the environmental review. And one thing to remember as well, not all those that are in favor of project show up and comment, and same on the other side, people that are engaged in the project or in providing public comment in the CEQA review aren't always necessarily going to say, hey, I think it's a great project, approve it. It's going to be more elevating their concerns that they have with the project, and so something to keep in mind. And the last component that you guys have seen already is kind of the last minute data dumps, where let's say an attorney group or some other group will provide a big lengthy letter saying, here's why the environmental review is inadequate, and here's a whole bunch of pages of nonsense that I'm going to provide with it, and you're going to have 500 pages to read of studies from other cities that have nothing to do with the project. And that's something that people do. We do, as staff, try to read through everything pretty quickly and see, is there anything that's a fatal flaw that we need to maybe take a pause, address, and make sure that we provide in the administrative record to overcome whatever that issue is. And so certainly you want to make sure that you're not just, if someone shows up with a hefty document, that you're delaying projects because they will take advantage of it. But if there is something that is important, it is always worth slowing down and taking a breath. No matter what the applicant says, it is not the end of the world if we need to also take a break and make sure that if there is a very important point, that we coordinate and get that information in before you guys make your final decision. Now we're going to go through some kind of environmental, kind of what the CEQA is and isn't, and kind of a fun hypothetical as well. So EIR itself, I know people have kind of say, and certainly in the comments you receive, you should prepare an EIR. An EIR itself is not meant to stop a project, is not required for contentious projects as well. So just because a project generates a lot of controversy doesn't mean EIR is the thing that you need to do. EIR does not tell you how to vote, it's purely to disclose what those impacts are. One thing that's always kind of interesting is certainly developers take the perspective that EIRs are more expensive, take longer, or more comprehensive than other environmental documents, and that's not necessarily true. Certainly there's a lot more state law requirements of what needs to go in an EIR itself, but you can have exemptions with multiple technical studies that justify those impacts as well. So you can still see a pretty wide gamut. It really depends on what the project is. I know that we've seen comments before in the city about a four-season EIR. That's not a term that exists anywhere in the California Environmental Quality Act guidelines. And that the EIR will be bulletproof, that's also not necessarily true as well. Certainly there can be comments and facts that are brought up, and so that's part of that independent judgment that's important. So I'm gonna have a very absurd project hypothetical. So we have a project here coming before you, has a number of different impacts that they're gonna do, but one of the impacts is gonna be clubbing baby seals. So the impact analysis itself is that it would list the impacts to those baby seals as a significant impact. So the fact that's doing that, that's a biological impact, that's a concern. So a mitigation measure that could be proposed is that project applicants are going to use wiffle ball bats as a way to soften the blow for those baby seals. So then the question is that still a significant unavoidable impact? Or is there any other feasible mitigation measures that can be done? You may say, nope, that doesn't quite do it, so it's still significant unavoidable, so then you're preparing EIR. And then the thing that's, I think, always important to remember is even though it has that significant impact, it's clubbing baby seals, no one wants that, does the project benefits outweigh those impacts? And if it does, you get to prepare overriding considerations and can actually still approve the project. So the EIR, just because you have significant impacts, doesn't mean that the project can't happen. That said, you can also say, hey, this project does not benefit us by clubbing baby seals, so we're going to deny the project. You can also use that, and that's part of your disclosure. The point is really it's disclosing the impact to help inform the decision. It's not to decide what you guys have to do. You can still approve the project despite it clubbing beautiful baby seals, but that's a. Yeah. I thought that was a cute picture. So. And so that's just a way to think of kind of the different components, the mitigation measure, the overriding considerations, and how it weighs into the decision. You're still able to make your decision. It's just based on using the facts to understand what is that impact. Now, CEQA itself is not perfect. It's not an advocate for or against the project, and itself is not the project. It's just merely the analysis of the project. As we kind of talked about even in the public hearing that we had just today, the CEQA process isn't necessarily to address existing problems. It isn't to say, hey, this is a problem that's happening over here. We're gonna make the project try to fix that problem. That's not what CEQA is allowed to do, and Supreme Court rulings also, the Nolan-Dolan Supreme Court examples also tie into that as well. It's not necessarily going to provide the analysis of every single possible outcome that can happen. It's more what is the likely outcomes of the project. And it's not necessarily meant to do the worst case scenario as well. It's supposed to be what is the project, what is it going to do, what is the impact? And so it's not meant to be the decision maker as well. And then it isn't always simple. And so with that, CEQA does have a number of issues. One of the terms that we had used when I was in school is kind of a paper tighter Each project and location is nuanced, so the rules and kind of expectations aren't always exactly the same. And then the court cases itself have really kind of evolved that determination as well. So there's a lot of different factors that can weigh in on kind of how CEQA is applied along those different particular impacts. Every city is different, their thresholds are different, the project itself is going to have its own different impacts as well. CEQA is also, as I mentioned, kind of used to delay projects. So certainly that bid data dump where people try to have you guys stop from making a decision, that's a way to delay a decision on a project. They use tools as a way to delay the projects through, let's say, lawsuits where they go, okay, the project's been approved, now we're going to go through, the discovery phase, the public records request, we're going to stop everything, and they're not going to be able to do anything until a judge weighs in or there's some sort of cash settlement for a decision to move the project forward. And so a lot of people, attorney groups, other groups like to use CEQA and oppose projects and hopefully win attorney fees for their advocacy role that they have. But then certainly also just to stop projects. And then, one thing that's also one of the implications of CEQA is merely for disclosure. It isn't necessarily to improve the environment. The lawsuits that happen in CEQA really, when you do have those projects, those with money are able to starve off kind of that lawsuit. Those that don't, or kind of a smaller scale project, really can't do that. And then kind of the inverse is true as well. Sometimes you'll have, wealthy, more affluent neighborhoods that have a lot more funds that they can pull together to initiate the CEQA lawsuit, pay for an attorney to do that, whereas maybe you do have more disenfranchised parts of the community where they really can't engage on that too. And so it isn't always a very fair approach that's used. And the consequence is sometimes good projects simply lose out because of those challenges. And so we would certainly hope that CEQA reform may occur. However, Governor Brown had famously said that reforming CEQA was the Lord's work, so we'll leave it to the Lord. And then former Senate Pro Tem Darrell Steinberg also said that his CEQA reform bill was how to make no friends at. So when he started trying to do that, essentially everyone was like, no, we don't want to do this. And the reality is that, those that use CEQA to oppose projects want to make sure that process is there. CEQA does have a very fundamental role as well of disclosing environmental impact, so you still want to make sure that goal is there. And so being able to find a way to achieve that makes everyone happy has not happened. Most people are not happy with every single decision, and CEQA is certainly one of those. And so really what we're seeing now is just more this kind of piecemeal approach where certain projects, like affordable housing projects, may qualify for certain exemptions. And really kind of the last part, way to help safeguard the city. One is making sure that we follow a comprehensive and robust process, make sure that we have enough facts that help support your decision, but also reminding that CEQA applies to discretionary projects. So if there's certain activities where there really isn't necessarily a lot of subjective requirements that we can impose to projects where it really is, do you meet all this stuff? Then, if it is a ministerial type project, CEQA does not apply in those cases. And that's my CEQA 101. I could go into a lot of detail. I have worked as an environmental planner and have written plenty of EIRs and stuff, but I have a love-hate relationship with CEQA, and I could go on and rant on a soapbox for a long time if you wanted me to. So.
Well, if you want to go ahead and carry on. No, I think that was very good, very enlightening. With that, any commissioners have any questions? Really? Oh, I guess you did a great job, Ben.
All right.
No questions? Good job. Okay, what do we have? Any other next meeting? Any other?
Next meeting will most likely be the first meeting in June. So we'll get a few weeks off as a reprieve, and then we'll have a few items on that one. And so other than that, that's all I have. And yeah, hope everyone has a nice Cinco de Mayo and Memorial Day and all that stuff is coming up. So
Okay, meeting adjourned.
Music and Arts Festival, yes, that's this weekend. So